Hélène.
You're the chair of the Anti-Counterfeiting Committee, but as well you chaired the EU Anti-Counterfeiting Subcommittee, and with the subcommittee you worked very hard on the enforcement provisions of the trademark reform. Can you explain a bit how will the trademark reform help trademark users to enforce their rights?
Yeah, sure. Thank you for asking, Hélène. My personal involvement in the trademark reform process began as early as in 2011, and what is interesting, my two sons were born since then. The first one in 2011 when the entire process started. I know the story is much longer, but it started, at least for me, in 2011, and the second son was born this year when we expect to have a new legislation finally adopted. And yeah, no surprise, as an ACC member and chair, I focused on enforcement-related provisions of the trademark reform, in particular relating to anti-counterfeiting measures. And yes, the reform will bring significant changes in this respect, in particular in relation to counterfeit goods in transit, or so-called preparatory acts.
Okay, and let's discuss a bit more in details the counterfeit goods in transit provisions. Well, let's just kill the suspense and tell us what is in the trademark reform and how will the provisions work in practice?
In a very few words, under the new laws, the trademark owner will be allowed to prevent bringing counterfeit goods from third parties to the territory of the European Union, no matter what customs procedure will be applied to them, including transit and transshipment, and even if those goods are not to be released for free circulation in the European Union. So it's going to be a significant change, and it will be made clear for the customs official throughout the European Union that they are allowed to take action to detain counterfeit goods which are in the transit situation, which today is doubtful or even impossible depending on the member state, especially after famous or infamous ECJ ruling in Nokia Philips case. So that will be a significant change. However, this right will not be exercised in the situation where, in the course of subsequent proceedings instituted in order to confirm infringement after customs detention has been made, which doesn't always happen, only if the simplified procedures were not applied. If in the course of such proceedings the owner of goods or the declarant is able to prove that the trademark owner would not be entitled to prevent those goods from being put on the market in the country of final destination. So the situation in the country of final destination will play some role.
So quite a big change ahead of us, huh? And we know that the counterfeit goods in transit provisions have been extremely controversial throughout the whole legislative process. Why do you think is that so?
First of all, it was because of a fear that the proposed solution, in particular in their initial shape, would be in conflict with the legitimate trade and principle of freedom of transit guaranteed by various WTO agreements, and that was the reason for the Netherlands, for example, to abstain from voting on the trademark reform quite recently. They made some references to the access to free access to generic medicines. They presented some examples of customs seizures which gave rise at that time to WTO disputes against European Union. In my personal opinion, most of these fears, most of these controversies result from some kind of misunderstanding, misbeliefs, and mixing some terms like generic medicines, which can or cannot be patent infringement on one hand, and fakes. And it was always clear for INTA, and it is quite clear in the new provisions, that the real aim of these provisions is to fight with international trade in counterfeiting, counterfeit goods.
Well, yeah, obtaining strong provisions on counterfeit goods in transit was and it is a key priority for INTA due to our long-term commitment on the fight against counterfeiting. What actions, other than educating on those misbeliefs, did INTA take to have strong provisions?
Not only strong, Hélène, but also, or first of all, clear and fair. And at the same time securing interest of brand owners, of course. So a lot of actions have been made since the very beginning of the process by INTA. It was through INTA staff, in particular INTA Brussels team led by Krystyna Sluszyńska and yourself, Hélène. It was through EU subcommittee of anti-counterfeiting committee, through its individual members. So we are all responsible for drafting INTA positions on at each level of trademark reform or even between. We were always prepared for several possible scenarios, several options. We always had our plan B or even plan C. You know, there were numerous meetings, consultations, official, non-official, individual, collective, some collective actions with other associations, joint letters with IP and non-IP organizations. So at the end of the day, I believe we will have a solution which I think we will be treating as at least inspired by INTA. Of course, it is not ideal, nothing is, but we must be aware that it's a result of a compromise which was quite difficult to be achieved.
Indeed. And I mean, you've been actually following the legislative process also from a national perspective by being in close contact with the Polish authorities, and we know that member states will need to transpose the directive but also implement the regulation into their, transpose the directive in their national legislation and implement the regulation. Do you foresee any challenge or issues in terms of implementing the reform at member states level?
I don't see any difficulties in, mere implementation of new provisions into national legislation. I mean, enforcement-related provisions. However, as it is the case now with customs measures regulation, we can face some difficulties when the new provisions will come into effect in real life, and we will see. I think that they will be treated in a different way in real life, and that will be another task for INTA to monitor this process, monitor implementation, monitor how the new provisions work, and of course to react whenever possible in the best interest of brand owners.
Well, thank you so much, Bartosz, for your insight.
Thank you, Hélène.